Welcome to the deep dive. We're cutting through the noise today to bring you a critical look at the future leadership of the India's judiciary. We are focusing on a pivotal moment, the formal recommendation of the next Chief Justice of India, Justice Surya Kant. I'm Priya Chakraborty and my co-host is Anil Agrawal.
That's right. It all kicked off officially Monday, October 27th, 2025. That's when the current CJI, Justice Gavai, formally put Justice Kant's name forward.
So our mission today is to unpack the significance of this transition, look into the formal process, how it all works, and most importantly, explore Justice Kant himself, his background, which is quite something, and his key judicial contributions.
Absolutely. And just to frame it, this recommendation means he's set to become the 53rd Chief Justice of India. He'll take the oath on November 24th, right after CJI Gavai retires. And here's a key point, a really significant one. He will be the very first person from Haryana to hold this office.
Wow, okay. First from Haryana. That immediately puts a spotlight on representation, doesn't it? And his background, which, yeah, we definitely need to circle back to. But maybe let's start with the nuts and bolts, the protocol involved here, okay? Because it's not just about seniority, is it? There's a very clear procedure.
Indeed, it's all governed by something called the Memorandum of Procedure, or MOP for short. The whole thing really started formally when the Union government reached out to CJI Gavai, that was on October 23rd, basically asking for the name of his successor.
And the MOP lays out the rules.
Yes, very clearly, it mandates appointing the senior most Supreme Court judge who is considered fit to take on the role. It's a system designed really to ensure continuity and limit political influence in this election.
Got it. And the timing is quite tight. CJ Gavai retires November 23rd.
And Justice Kant steps in the very next day, November 24th.
Now, his tenure, it's expected to be about 14 months until early 2027. That seems relatively short for a CJI. What does that usually mean in practice?
That's a great question. Yeah, around 14 months until February 9th, 2027. A shorter tenure like this often means, well, you have to prioritize immediately. There isn't really the luxury for long-term multi-year projects. So historically, CGIs in this position tend to focus hard on things like administrative efficiency, maybe clearing case backlogs, or pushing through one or two specific reforms they know they can achieve in that time.
Right? Real pressure cooker environment, perhaps.
Could be. For Justice Kant, we might expect him to really lean into areas where he's already shown a strong interest, like access to justice, maybe governance, accountability, things he's already working on.
Okay, now I was struck by the current CJI's endorsement. CJI Gavai didn't just make a formal recommendation, did he? He said Justice Kant was an asset to the institution, suited and competent in all aspects. Strong words.
Very strong. But what really stood out, I think, was why he felt so confident. He made it quite personal.
How's that?
Well, CJI Gavai specifically linked Justice Kant's own background, his life experiences, to his suitability. He said, and I'm paraphrasing slightly, like me, Justice Kant comes from a part of society that has faced struggles. This makes me confident he'll understand the pain of those who need the judiciary most.
That's quite a statement from a sitting Chief Justice. And if I might paraphrase CJI Gavai, this makes me confident he'll understand the pain of those who need the judiciary most. And I was wondering if bank retirees waiting for the long-running MC Singla case for Updation to conclude fall into that category.
Yeah, excellent point. MC Singla case has been running since 2008. Almost as long as Yeh Rishta Kya Kehlata Hai, India's famous soap opera, has been running.
It's almost explicitly saying that lived experience of hardship is valuable, maybe even necessary for leading the judiciary effectively today.
Exactly. It suggests a kind of evolving self-awareness within the judiciary, perhaps. It's an acknowledgement that legal expertise is crucial, of course, but empathy forged through personal struggle is also vital, especially when dealing with issues affecting the poor or marginalized. It connects the person directly to their judicial philosophy.
And that's a perfect bridge to his story, his rise, as you called it, from a humble village background. I suspect many listeners might not fully grasp just how different his starting point was.
It's a truly remarkable journey. Justice Kant was born February 10th, 1962, in Petwar. It's described as a small, nondescript village in Hisar, Haryana. You have to picture rural India back then. Forget any kind of privilege associated with, say, Delhi power corridors.
So paint us a picture of that childhood. What details really jump out?
Okay, well, picture this. Up until class 8, he went to the village school, a school that had absolutely no benches. Kids just sat on the floor.
No benches.
No, and he talks about typical rural life, working in the fields when he wasn't studying. What motivated him and his friends apparently was simply the hope of getting a government job someday. That was the dream. He even recalls that electricity was a rarity, so studying often meant gathering with friends under dim lamps. Just imagine the focus that required, real adversity.
And that sense of isolation too. The fact that the first time he even saw a proper town or what passed for a city then was when he traveled to Hansi for his Class X board exams.
Exactly. That journey from a benchless school in Petwar to potentially the highest judicial bench in the land, I mean, it speaks volumes about his personal drive and determination.
Incredible grit clearly there from the start. So, moving on from his origins, let's trace his legal path. He got his LLB from Maharshi Dayanand University, Rohtak in 84. Then what?
He started practice pretty quickly, first at the Hisar District Court, but then he moved to the Punjab and Haryana High Court in 1985. He built strong practice there, specializing in constitutional law, service matters, civil cases.
And he rose quite fast.
Very fast. By July 2000, he was appointed Haryana's Advocate General. And get this, he was the youngest ever to hold that post in the state, only 38. He was designated a senior advocate just the next year in 2001.
So, clearly making waves early on. And his elevation to the bench wasn't far behind.
No, he became a permanent judge of the Punjab and Haryana High Court in 2004. He was 42 then. He served there for well over 14 years.
Okay, a long tenure at the High Court.
But here's something that really underlines his commitment to continuous learning, something quite unusual. While he was already serving as a High Court judge, he didn't stop studying. He pursued and earned a first-class master's degree in law from Kurukshetra University in 2011.
While on the bench,
That is unusual. Shows a real dedication to the academic side of law too.
absolutely. A deep intellectual curiosity. After his long stint at the PNH High Court, his path continued upward. Chief Justice of the Himachal Pradesh High Court in October 2018, and then elevation to the Supreme Court in May 2019.
Was there any specific reasoning given by the collegium when he was recommended for the Supreme Court? Anything beyond seniority?
Yes, actually. The Collegium resolution specifically mentioned giving due weight to ensuring adequate representation from all high courts on the Supreme Court bench.
So his elevation was also seen partly through the lens of bringing diverse judicial experience from across India to the top court?
Yes, that connects back to the Haryana point and his administrative interest, perhaps. Okay, let's pivot now to his judicial philosophy and his work on the bench. He's known for what? Humility, measured wisdom, empathy.
That's the reputation, yes. Combining legal rigor with a certain groundness. If you look at his judgments, key themes emerge. Definitely governance, accountability, social justice, administrative fairness. You see a consistent concern for the ordinary citizen, for public resources. Things you can easily trace back to that Petwar upbringing.
Okay, let's unpack a few landmark decisions then. The Jagendra Singh Varta Ministry of Environment case seems pretty indicative. What was that about?
Yes, that's a really important one. It was a unanimous judgment he authored. Essentially, the court held that government schemes can't just extinguish local water bodies, like village ponds, which the judgment explicitly called public utilities, even if they offer alternatives somewhere else. They ruled it violates Article 21, the right to life. This is crucial because it interprets Article 21 not just negatively, as freedom from being killed, but positively, as a right to a dignified life, which includes access to essential public resources like water.
So, using Article 21 to protect community resources and the environment, basically.
Pretty much. It shows that sensitivity to basic necessities. We also see it in other areas like prison rights.
Ah, yes. Tell us about that. the judgment on conjugal visits.
Right? That was during his time at the Punjab and Haryana High Court. He delivered a significant judgment on the right of inmates to have conjugal visits, or alternatively, access to artificial insemination specifically for having children. It showed a real willingness to look beyond just the punishment aspect and affirm the basic human dignity and rights of prisoners, even in controversial areas.
Hmm. Switching gears a bit to criminal law, he also authored a key opinion in CDI v. Sakru Mahagu Binshuar. This dealt with commuting sentences, right? Why was that important?
Yeah, that was about Section 57 of the Indian Penal Code. There was some ambiguity because, for certain calculations, life imprisonment was sometimes treated as equivalent to 20 years. Justice Kant's opinion clarified things. The case involved commuting a death sentence, and the court upheld commuting it to 25 years of actual imprisonment. The ruling made it crystal clear that Section 57 doesn't mean life imprisonment automatically caps out at 20 years. It brought much needed clarity for sentencing.
Okay. So, important for legal certainty there. He was also involved in a major public order situation while at the PNH High Court, wasn't he? The Dera Sacha Sada incident.
Oh, yes. That was huge. Back in 2017, after the Dera chief was convicted, there was widespread violence. It was a massive challenge. Justice Kant was part of the full bench that had to step in. They ordered the sanitization of the Dera premises, basically clearing it out, and also directed a central agency probe into financial irregularities. It really demonstrated the court asserting its authority to ensure accountability and restore order, even against a very powerful group.
Right, a real test of judicial administration under pressure. And speaking of administration, that brings us to his current role, which seems to perfectly align with his philosophy. Executive Chairman of the NELSA?
Exactly. The National Legal Services Authority. His work there is probably the most direct expression of his commitment to social justice and access. He's really been championing reforms focused squarely on making justice accessible, boosting legal literacy, and using technology to reach people who normally couldn't afford or access legal help.
Can you give us some examples? What kind of tangible initiatives have come out of NELSA under his watch?
Well, they've been pushing things like setting up 24-hour legal aid clinics, which is a big undertaking. So, developing e libraries for legal resources and using mobile legal aid programs to actually go out to underprivileged communities, remote areas. Generally, he gets credit for pushing administrative efficiency, trying to bring more consistency across the different high courts, especially in how they monitor the performance of the district courts. It's all geared towards making the system work better for everyone.
So, if we pull all these threads together, the relatively short tenure, the background driving is empathy, the specific focus in his judgments on basic resources and access. What's the main takeaway as he prepares to become CJI?
I think Article 21, with a clear focus on the marginalized and on public resources. His personal background almost guarantees a heightened sensitivity in cases dealing with things like land acquisition, compensation, environmental protection. He brings that combination of legal clarity and lived understanding of what's at stake for ordinary people.
So, given that consistent focus on linking basic amenities, water, environment directly to the fundamental right to life under Article 21, and keeping in mind he only has about 14 months, here's something for you, the listener, to think about. How might this intense, possibly urgent perspective influence the Supreme Court's approach? Could we see a more immediate, maybe even aggressive judicial stance in PILs involving scarce resources or government accountability during his tenure?
That really is the core question, isn't it? Will the short time frame push him toward trying to make swift, perhaps deep changes, focused on that access to justice principle?
Something to definitely watch as Justice Kant takes the oath on November 24th.
That's all the time we have for this deep dive. Thanks for joining.